Alright, so this is over chapter 3 and 4. Some of the important parts from chapter 3 were the jurisdiction, the venue, structure of the court system, the actors in the legal system, the adversary process, the steps in civil litigation, and the global dimensions. The jurisdiction is a power of court to hear a case and render a binding decision. Original jurisdiction is the power to initially hear and decide a case. Appellate jurisdiction is the power to review a decision previously made by the trial court. With venue, it is a geographic location of the court conducting the hearing as prescribed by state. It's based on the residence of the defendant, location of the property in dispute, and the location in which the incident of the dispute occurred. Some of the actors would be the attorney, the judge, the jury, and that's what I have written down. But the attorney is the legal representative of the parties before the court, and the House and counsel. They have to have qualifications, which are law degree, pass bar exam, and high moral character. There's a attorney-client privilege, which is that info may not be revealed by the attorney without the client's permission, and the work product doctrine, which is documents prepared by an attorney in conjunction with the client's cases. When it comes to the judge, there's a trial judge, which presides over the trial, the appellate judge, which serves on panels and reviews the court cases, the state court judges, which are elected or appointed, and the federal court judges, which are appointed by the president. There's judicial review, which is the power to determine whether a law is passed in the legislature violates the Constitution. The judicial restraint, which is courts should refrain from determining the constitutionality, and the judicial activism, which is the active role in encouraging change. The other one is a jury. There's a petit jury, which is 12 citizens. The case is pronounce whether the defendant is guilty or not guilty, and then the grand jury, which is 12 to 23 people, which they decide in private whether or not there's enough evidence to make the person guilty. When it comes to the adversarial system, judges hear evidence and arguments presented by both sides in a case. The steps to civil litigation are the trial, the appellate procedure in the class action cases, and the global dimension of the American legal system are disputes with other nations likely to increase due to growing multinational corporations and trade relations among the nations and differences in legal systems, procedures, rights, and remedies. And then in chapter 4, there's a lot that I found important. The first one was negotiation and settlement, which is disputant parties informally try to resolve differences, requires each party to give something up in exchange to getting something from the other side. Mediation, which is a disputant party selects an expert in the dispute area to help reconcile the differences. The arbitration, which is they submit their disagreement to a mutually agreed upon neutral decision maker or one provided for by the state. The mini trials, which are lawyers for each side, present the case at a proceeding referred by a neutral advisor. Early neutral case evaluation, which is where they explain their respective positions to a neutral third party who evaluates strengths and weaknesses of the case and guides the parties in reaching a settlement. The private trials, which are the cases that are tried in private by a referee who is selected by them and empowered to a binding judgment. And then the summary jury trial, which is an alternative dispute resolution method that consists of a non-binding jury verdict, settlement conference, and an abbreviated trial. The court annexed ARD, which is the court mandate that the disputants go through some formal ADR process before the case is brought to the trial. And the global dimension would be that the ADR is widely favored in the international contracts.